Hi, my name is Jimarielle Bowie, and I am an attorney here at the Nieves Law Firm. And today I'm going to talk to you about the burden of proof and a domestic violence restraining order. The burden of proof in a domestic violence restraining order is a preponderance of the evidence. And first we'll go ahead and dissect that and then talk about what you need to prove. So the burden of proof is basically the level of proof that you need to bring in order for a judge to decide in your favor. So many people have probably heard beyond a reasonable doubt. That is a burden of proof. And there's different burdens of proof in the court of law. We have beyond a reasonable doubt, which is the highest form of proof that you have. And then you have clear and convincing, which is a little bit less than beyond a reasonable doubt, but a little bit more than a preponderance of the evidence. It just has to be really convincing, right? And then the last one is, in the court at least, is a preponderance of the evidence. And so it's one of the lowest forms of proof we have within the court of law, but it still requires some form of convincing. And so preponderance of the evidence basically means more than 50%. And many people think, oh, that's like 51%. Not necessarily. It just means 50% and a feather. And attorneys and people in the legal field don't necessarily like to quantify the burdens of proof because it can be very convincing, but all it means is that it's more likely than not that what is being alleged happened. So in a domestic violence restraining order, a judge essentially just has to determine that it's more likely than not that what the petitioner alleged is what actually occurred. And so that's significantly less than beyond a reasonable doubt. It is a very low burden, but it's not impossible to beat. And so it's incredibly important to remember that just because it has a lower burden doesn't mean that you cannot beat it. It's still very easy to beat. All you have to do is put on or negate the evidence that's being put on against you. And so when it comes to a preponderance of the evidence, they don't just have, that burden in itself. They have to prove that by a preponderance of the evidence that the respondent committed past acts of abuse as defined by the family code. And so what that means is they have to prove by a preponderance of the evidence that the respondent engaged in abuse. And abuse can be defined by several different things. Abuse can be physical, it can be sexual, it could be coercive, or it could be anything that disturbs the peace. It's a very large definition of what is abuse. And so all a person has to do is just basically prove that by a preponderance of the evidence that the respondent has engaged in past acts of abuse. And that's the burden of proof in a domestic violence restraining order. If you find yourself needing a restraining order or needing to defend against a restraining order, please make sure to keep the Nieves Law Firm in mind and give us a call and see how we can help.